Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. If these questions and answers are helpful, like, subscribe, comment down below. It helps us to help more people just like you. Now, we have a question from YouTube user Small Brown Dog, who said to us, "Thanks Vince for all your help. Love the videos." Least I could do. I posted a similar question on yesterday's video with examples, but it seems more applicable to this video. I did not see that question. If you have a high probability of winning a high valued claim and are also eligible to recover attorney's fees, would it possibly make sense to pay an attorney hourly and cover all expenses out of pocket if you can afford to do so? I realize you'd be taking on all the risk if you lose, but also getting all of the award if you prevail. Will an employer be more inclined to settle a case quickly instead of dragging it out if they know you are accruing significant attorney fees that they may also eventually be on the hook for? Okay. So it's a question of economics and risk, as you already noted, right? I certainly have represented wealthy individuals who had claims that were of exceptional value, who wanted to pay on an hourly basis because they wanted to capture the entire value of their claim. It happens. Now, let's dig into that a little bit further, though. What does it actually cost to litigate a federal court case? Prior to the inflation explosion of 2020, between $60,000 and $120,000 if you're paying by the hour for representation, all the way up to and including trial. That's not really including some of the expenses, like that's not including what you're going to pay your expert witnesses and stuff like that, but we'll tack that on. We'll just call it $60,000 to $140,000. And that's certainly viable for some individuals. Some individuals have the scratch, they have the war chest, they can make that happen. And if you earned, call it even just $500,000 a year, and let's say that attorney just happened to win you, I don't know, we'll call it 4 years, right? In that world, in that scenario, let's just say you paid 140 grand and you won 2 million. Well, you came out way ahead, because that attorney, if they were on, like, let's say 40%, they would have covered all the expenses for you. They would have shouldered all that risk, but they would have walked away with 800,000 of your 2 million. Now, you might have gotten some of that back in an attorney's fees provision, depending on how the retainer with the attorney that you're working with is structured. But even then, what would you get back? Let's say you get back 300,000. Okay, so you're still up a couple hundred grand. Was it worth shouldering all that risk? For some of my clients, it absolutely was. Yeah, they came out way ahead, way ahead. Generally, those people are very, very sure about their claim. Sometimes this is tied to situations where you have kind of set, exactly what the damages are. You don't know necessarily exactly what the emotions will be, but like the economic value of a contract, right? Sometimes executives will have custom compensation packages with guaranteed payouts that have been breached because of discrimination or sexual harassment, something like that. And so they'll know the dollar value because their contract states it, right? I mean, if you're like, listen, hey, we want to have you here for the next 10 years as our CEO, and we guarantee you that over those 10 years, you're going to earn $1 million a year, so it'll be $10 million. Very silly contract, right? There's a lot that goes into custom executive compensation. These are very complex contracts, but this is, it's a hypothetical. We're keeping it simple. So it's a guaranteed $10 million over the 10 years of the contract, right? In year one, board member comes down and sexually harasses the CEO, and the CEO is like, mess you up. I'm going to mess you up. You keep this up. Board member keeps it up, and then the board terminates because the board member agitates against the CEO and forces the CEO out, breaching the contract. And you now have a pretty good idea that the economic damage, at the very least in that case, are worth about $10 million. Rare, but it happens. Certainly it happens. That CEO has every reason to want to capture the entirety of her $10 million payday, plus emotionals, plus potentially punitives, if it goes to trial, right? And probably also, if this is not the CEO's first round of custom executive compensation, right? Everything in corporate kind of goes lockstep, right? There's titles and levels, and a VP gets what a VP gets, a director gets what a director gets, so on and so forth, right? And you get to custom compensation levels, then you have people negotiating custom packages because they're higher end executives, or hiring attorneys to negotiate for them. And that's how it's done at that level, right? And that's where people really make the money, as we say, right? So if this is the CEO's second round of custom executive compensation, and let's assume she's been smart with her money because she's a CEO and it's been going well, probably has the war chest to pay the attorneys to fight the case all the way to the end without giving up a percentage. She doesn't have to worry about the fees getting covered. She doesn't have to worry about the hourly rate for the attorneys. Now, earlier I said, before the inflation boom of 2020, which ongoing today, depending on who you ask, that was the price range. 60 to 140 is, I think, what we landed on. I think it's a lot more today. Every firm that survived has increased their prices significantly. In part because inflation makes dollar bills worth less than they were before, but also just because the number of firms in the marketplace has constricted. There are less employment firms available today, I believe, than there were in 2019. At least to the best of my ability. I don't pretend to really keep the most careful eye on it, but I generally have my finger on the pulse of the industry through gossip and just observing and people commenting this channel. Like I pay a lot of attention. I also get information from some research groups who kind of research about the industry and things of that nature. Because it's always fascinating. You never know who the big players are until like the research comes out. There's lots of firms like, we're the big boys in town. Starving to death. Ain't nothing, going out of business, right? And then the people making just houses out of cash, just bricks of cash, because they're helping a lot of people, are completely silent and like nobody knows about them. Just literally taking bricks of cash and using it to build homes because they don't know what to do with their money, right? So it's always very funny to me when you like juxtapose the big talkers against the real walkers. But I digress. So anyways, I have a general notion of the industry, and I think there's fewer firms in the U.S. now doing plaintiff side employment work than there was in 2019. And that's regrettable. I think it's really unfortunate for a variety of reasons, but one of the chief of those is that it's driven prices up. There's less supply of plaintiff side representation in the United States in 2023 than there was in 2019, as far as I can tell. And so that, coupled with inflation, has just pumped those prices up. And so hourly rates for a lot of firms have doubled at a minimum. And I'm aware of a few that have tripled. So I don't know if that means that a trial is going to cost you $300,000 to pay for in federal court. Just the entirety of the litigation, not just the trial, right? I don't know if that's true today. And of course, it's variable. It depends in large part upon the firm you're working with and the deal you arrive with them and how confident they are that you'll actually pay their hourly bills, right? people are very confident that you'll pay and you pay as agreed and there's no issues, there's no fights, there's not a constant bickering about the bill, you'll probably get a better rate. If you worked with a firm before, you'll probably get a better rate. If you have a good working relationship with the partners of the firm, you'll probably get a better rate, right? Like there's a lot of things that go on there. Also, it's important to remember that like there's this tension of like when you're paying hourly, firms don't want to be your creditor. So a lot of firms will say, yeah, put the money in retainer in advance. And when we're within like 10 grand of billing out the retainer, we'll let you know so you can replenish. Because at the point where you're just billing hourly and then later saying, hey, you owe us for the hours we billed, you're basically that person's creditor. And firms don't want to do that, right? They're already not thrilled about not getting their percentage. They're probably not excited about working on an hourly basis, although you're helping people and you're guaranteed money, so you shouldn't be that sad about it. But obviously the upside is a lot better on a good case if you have a percentage. Devil's in the details, depends on the percentage, depends on a variety of things, right? But generally speaking. So you'll get a better rate if you have a retainer that the firm's billing from that they can feel confident about. They're not your creditor, right? There's a lot of things going on there. So there's a lot of tension in the hourly rates and things like that. I'm like reluctant to say that I think a federal litigation plus trial on an hourly basis would cost $300,000 today. That's what the math is telling me. When I look at the math and when I try to extrapolate from data, that is what the data is telling me. But that boggles my mind. I don't know if that could be true. I think, I hope there's probably some kind of volume deal in place for all those hours. I mean, but I don't know. I don't pretend to know. No one in the past 2 years has hired our firm to do a trial on a purely hourly basis that has gone to completion that I'm aware of. So I can't tell you outright it's 300 or it's 200, but I can tell you outright it's not 140 anymore. It's not 60 to 140 anymore. It's probably 120 to 240 or something like that. That's what feels right to me. And if you can afford that and you want to take that risk on, do it. That's incredible. You could end up way ahead. That's why the firms do it, right? The firms do it. Now, the firms do it in aggregate, right? So they tend to know how many cases they win when they try a case, and they tend to know how many cases they settle when they take a case. And in aggregate, they're fairly confident that they're going to make money. It is the different beast when you are working with one case, because wild stuff can happen in one case, right? Like unexpected things happen that don't usually happen. Like without ever referencing any of my own cases, people do crazy things. People take a sleeping pill, get on the phone to say wild things, and they can't testify anymore because everybody hates them. Right? Strange power fluctuations destroy large banks of computers, destroying evidence before it can be produced in discovery. Right? These things happen. And in one case, the risks that you run can be much more terrifying than they are over 100 cases, 500 cases, whatever it is, right? So there's a reason why the firms have a higher tolerance for the risk of taking a case than most individuals would. But if you've made a fully thought out and well-reasoned calculation of the risk, and you feel it's a good deal for you, and you want to capture the entirety of the value of your case, more power to you. And if any firm refuses that to you, I'm not okay with that. Not even a little bit. Anyways, Small Brown Dog, I hope this answers your question. If it did, like, subscribe, comment down below. Helps me to help more people just like you. I think I already said that. If it didn't, let me know down below how I have failed you, and I will try to provide follow-up.